Hey out there, legal warriors. Reckless driving. That's one of the most serious criminal traffic charges in Washington state that is not a DUI. It might surprise you. It's easier than you think to get charged with reckless driving. It's pretty much whatever an officer says it is. So if you're interested in how someone can be charged with reckless driving, and more importantly, how we might defend that type of charge, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. Now I'm just going to jump right into it. Reckless driving, what is that? Well, that's a criminal charge in Washington state. It's under RCW 4661 500. That's 46.61.500 if you want to search that yourself, and we're going to link it in the description. It basically means a willful and wanton disregard for the safety of others when we drive. So driving a motor vehicle in a willful and wanton disregard for the safety of others. So what does that mean? And you heard me say it in the introduction. It pretty much means whatever an officer says it means. If you're speeding too fast to the officer's liking, they could give you a speeding ticket, which is a traffic infraction, or they could give you a criminal charge, a very serious criminal charge of reckless driving. If they don't like the fact you're in a traffic accident, instead of a ticket of failure to obey, they could give you reckless driving. Comparing speed, street racing, that's reckless driving. Pretty much anything the officer wants it to be, if they can sort of say it was on purpose, willful and wanton, they can charge someone with reckless driving. So why do I say it's a serious charge? It's a serious charge because reckless driving is a crime. It's a gross misdemeanor crime. That means the maximum penalty is 364 days in jail and a $5,000 fine. And if you get cited with reckless driving, you're going to have to go to court. And not just like a traffic ticket, a court with multiple court dates, an arraignment, where we have to plead not guilty, right to a jury trial, a bunch of court dates, where if we're convicted, not only can we be put in jail for 364 days, there's actually a mandatory driver's license suspension. On a reckless driving charge, if you're convicted of reckless driving in Washington state, the very least suspension you'll have will be a 30-day license suspension. And to get your license back, you're going to have to maintain high-risk insurance SR22 insurance for 3 years. And the worst part, of reckless driving conviction charged as reckless driving, you're not even eligible for an ignition interlock device, an ignition interlock license, I should say, to drive wherever you want to drive. So it's actually better if you get charged with a DUI, believe it or not, because if you suffer a suspension under DUI, you can get an interlock license to drive wherever you want. On a reckless driving conviction, you can only get basically an occupational license, which is only going to let you drive to and from work. So while it's a lesser type charge than DUI, some of the penalties still haven't really caught up with the way that the DOL thinks about things now. And so your suspension can be even worse. So if you're charged with reckless driving, what you don't want to do is just go in and plead guilty, right? Don't do that, because there's going to be some ways that we can defend you and hopefully get you out of a reckless driving charge. So let's move into what are our ways that we can defend someone for reckless driving. And it may not be what you think. Okay, the first thing you're going to think is, hey, just show the driving wasn't reckless. Well, remember, it's not really defined. Willful and wanton disregard for the safety of persons or property. One prosecutor might think going 50 in the 35 is speeding, while another prosecutor might think 50 in the 35 is reckless because there's people around. If it's a 35 mile per hour zone, they might think, near the mall, something like that. So typically, we don't want to just rely heavily on the facts to defend the case, because then we're going to get stuck likely at a trial. And nowadays, if we can avoid a trial, avoid a jury trial, that's usually a good idea, because at a jury trial, we don't control the outcome. The jurors do, right? So we'd like to find a solution how we can avoid a reckless driving conviction without having to risk what a jury of our peers says about whether or not they think our driving was reckless, because it's pretty easy for juries to convict people, especially nowadays when everyone's mad. right? Everyone's mad politically, economically. Everyone's looking for a scapegoat, and the defendant is perfect for that. So what we would rather typically see someone do is do some type of educational classes so we can show the prosecutor that whatever happened in the past, even though we may not agree with how bad it was, isn't likely to happen again. So in most cases, that might mean doing an aggressive driving class. You can look it up, National Traffic Safety Administration, NTSA, Level 2 would be typically an aggressive driving class, and a lot of that's available online. Or there's Level 1, which is defensive driving, which is less long. We would generally advise do more than not, so you'll have a better effect on the prosecutor. So if you can do that aggressive driving type class, that's going to put your attorney in a better position for them to try to negotiate your case and show the prosecutor that, look, well, we don't think it was really reckless. The driving still wasn't great. And look, I've had my client do an aggressive driving class, so therefore you don't need to worry about taking a chance on my client. This isn't going to happen again. So if you do that aggressive driving class, now your attorney can point out the things where it may not be reckless. Maybe it was just careless that we weren't paying attention to our speed. Maybe the officer doesn't have the fact pattern right. And maybe, they've got a video that even shows that some officers have dash cams in their cars. So let's say we do our class and that we negotiate with the prosecutor. What's the outcome that we should expect to try to get in defending a reckless driving charge? Well, if we're going to avoid a crime, the next best thing we can get, and the most common reduction from reckless driving, is taking it all the way down to a traffic infraction. The traffic infraction most commonly we can see a reckless driving reduced to is called negligent driving in the second degree. That means driving in a manner that was negligent, basically, but it's not criminal. It's a pretty expensive traffic ticket, over $500, but it's not a crime. It doesn't suspend your license, and not a crime is really what we're looking for, right? Sometimes you might be able to get reduced to a speeding ticket or something else. But typically speaking, there's no lesser crime the prosecutor can reduce a reckless driving to. They could change it to reckless endangerment, which doesn't suspend your license, but it's still criminal traffic, so that's not so great. If they reduce it to a traffic infraction, you just pay a fine and then you're done. There's no probation, there's nothing like that. So trying to get your reckless driving reduced to the traffic infraction, negligent driving in the second degree, is one of the main things that a good attorney will try to do based upon you doing some classes, hopefully based upon you staying out of trouble during the intervening period, right? It's going to take months and months and months for this case to resolve. No new traffic infractions, please, while this is going on, and certainly no crimes. But hopefully the attorney can use your class, your lack of any history, and what the problems are with the case. So let's say that doesn't work. Let's say that the prosecutor's not interested in a driving class, or you've got a really terrible driving record. Then what do we do? Well, now we might have to start looking at the facts of the case, right? More heavily delve into the facts. What makes this particular case reckless? And we have to focus on those terms: willful and wanton disregard for the safety of persons and property, right? So willful and wanton means not an accident, right? We weren't just being distracted, right? We didn't fall asleep. Falling asleep wouldn't be reckless driving unless, we're being irresponsible and we were, had a huge breath test, but of course, then that'd be a DUI. We have to look at, was the light yellow? We didn't run a solid red, right? In that type of case, maybe that wasn't willful and wanton. Maybe it was just negligence, right? And also we can focus on disregard for the safety of persons or property, right? So that sort of suggests that if we're driving really fast in an open field and there's nothing to run into and there's no persons or property there, maybe that's not reckless driving because there was no persons or property besides our own that we needed to worry about, right? That one's a little harder to come up with, but if you're doing something in an empty parking lot, like donuts in an empty parking lot, we also often see that charged as reckless driving. A defense we might say is, well, where is the persons or property that we're going to run into, right? They're not going to damage a stone wall, probably. There's no other parked cars and there's no kids around or no other pedestrians around. Well, I might be stupid to be doing donuts in a parking lot. Maybe it's not reckless driving. Maybe it's more like negligent driving, which, of course, Negligent driving in the second degree is an infraction, and that's typically what we're shooting for. Finally, if we can't come to a resolution, we have that right to trial. You have a right to a jury trial, and you can also waive jury and ask for a judge trial. And sometimes you might want to waive jury and ask for a judge trial because a judge is going to be around the block more and know what reckless is versus not. So ask your attorney if you're going to be better off in front of a judge trial or a jury trial. Usually, if we have a technical defense, we might be better off with a judge trial. But, your attorney is going to know what the judges are like in your particular court. I can't speak to that here in this video. Last resort, let's say the prosecutor won't give you a straight reduction to negligent driving in the second degree. You could ask your attorney to get a slow reduction to negligent driving in the second degree. It's called an SOC, a stipulated order of continuance to a lesser charge, if you stay out of trouble. So what's the prosecutor get out of that? Well, it's a contract where if you get in trouble during the continuance period on the contract, let's say stay out of trouble for 12 months, have no infractions, the contract might say, hey, if you get an infraction in the next 12 months, you're guilty of reckless, but if not, you're going to be guilty of neg 2. So that's risky, right? And so that's a last resort to ask for that. But if you can't get a straight reduction and your chances don't look good at trial, that might be something to ask your attorney about. So I hope you found this video useful. If so, please like and please subscribe. More people get the help they need. And more importantly, if you're charged with a crime in Washington State and you need some legal help, feel free to give my office a call. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.